Justice stipulates that legal education needs to promote awareness of ideals and ethical duties of lawyers, human rights, and fundamental freedoms. Within our context, Kenya is a plural legal system, which means that we have in existence more than one legal order in the social field. And this impacts access to justice. We have state law, constitution statutes, we have customary law, we have religious law, and we need to ensure, because the Constitution allows these laws, we cannot actually exclude them when we are talking about access to justice. Access to justice in a plural legal system requires engagement with plural norms, actors, structures, and interests. And I think we as lawyers will be a little bit uncomfortable when we are told to interact with traditional justice institutions. And it's actually laudable that now we see this happening. My fear is that when lawyers go into the traditional justice access realms, what we do is to try to make them like what we know, which is formalizing the informal. And once you formalize the informal, you remove it from the people that it serves. So in essence, we need our law training at university and also at the advocates training program levels to begin to think about the extent to which we are bringing in these norms, actors, structures, and interests. And it is within that context that I begin to talk about disruption. Fortunately, the word disruption now has a positive connotation. You know, before when you say disrupt, you are seen as an enemy of peace. But now, disruptors are actually the people who find new ways of doing things. And I'm saying that law training and practice in Kenya is very oriented towards the private benefit ethos. We must imbue legal training and delivery of legal services with a public good or public benefit ethos, which calls for the disruption of the way in which we teach law and the way in which law is practiced by asking ourselves hard questions. I started asking, why do we invest in the judiciary? How many Kenyans does the judiciary serve? I want to ask another question, which affects a place that I am intimately connected with. What is the role of university and legal education in society? How poorer would Kenya be if we said we were not going to train lawyers anymore? And why do we invest in legal education? What is the raison d'etre of legal education? Universities and other legal education providers have a role to play in national development. Once there is investment in yourself, you need to give back. And the way in which we give back as lawyers is by facilitating democratic governance and the rule of law. Yesterday, I was listening to Professor Kivutha Kibwana, the governor of Makueni, talk about the rule of law or the rule by law. And you see, both, whether you're ruling by law or the rule is of law, lawyers are what Professor Lumumba says they will be either in front to the usual way of teaching law. You know, because you will not just be sitting at the front pontificating, you need to get your hands dirty with the problems that people are facing. So we should aspire to have clinics in law schools aligned to the courses taught at the law schools. And we should, of course, link the clinics to like-minded legal practitioners, but also policymakers. Legal aid schemes enable students to provide free legal assistance, assist in the preparation of cases, etc. And as part of clinical legal education, they facilitate the cultivation of professional skills and service orientation for potential lawyers. So lawyers are able to develop perception, skills, and sense of responsibility for professional life. And I am saying to disrupt, we must look at a professional life that is not anchored to only those who can pay. We must also be so passionate about justice that injustice, because people can't pay, is abhorrent to lawyers. They comprehend and assume responsibility for protection of individual rights. But I think legal aid clinics are very critical to consciousness raising because they provide legal services to the poor. There is a point at which I got law students to work with me on a project in the slums in Mukuru, and it was raining. We were looking at access to water and sanitation. And the understanding of the context. These are people who did not know that people even buy water in jerry cans, or there are no toilets in places. And I'll limit that discussion because it's just before lunch. But the students were horrified. So you need to raise the consciousness of students, because if we don't raise that consciousness, then we are going to have lawyers who are just looking at making the most money, but are not thinking about the problems that society has and how they can be engaged in sorting those out. How else do we disrupt? I like talking about this. We must decolonize legal education and legal practice. Legal aid cannot just be about formal law when constitutions allow different laws and different ways of accessing justice. If you look at our Article 159, and you will see that as lawyers move to other systems, they move to what they are comfortable with, ADR. But what about TDR, the traditional justice systems? Law clinics must decolonize the legal profession by addressing justice concerns from informal systems used mainly by the poor. Basically, this has to come from our decolonizing law in law schools and in our law teaching and practice. So as we teach law, we must have a Kenyan flavor. And if the Kenyan flavor is just about an expensive suit and a good gown, then that is for the cream. It is not reaching the Kenyan along the streets. So justice solutions in legal aid clinics need to be tailored to our Kenyan situation. I was very impressed when I visited University of Malawi Chancellor College legal clinics. They have very vibrant clinics that actually also look at traditional justice systems. And I have not had in my not so long life as an academic as incisive a discussion of traditional justice systems as I had from third-year law students at Chanco. So in concluding, given the limited access to justice and the fact that people resolve disputes without recourse to lawyers, lawyers are at the risk of becoming irrelevant if they do not move close to the unreached populations. This calls for a change in the nature of lawyering, and we need to assault the monopoly that limits access to justice by reprogramming lawyers to move from what is in it for me to being public good and public interest spirited. And this can be done by making clinical legal education a mandatory part of law training. We need to identify clinics that are best suited for particular law schools. CLE requires schools to have a niche. So if your niche is commercial law, then let us have a very vibrant commercial law legal aid clinic in that school. And we need to resource, and I think this has also been said in the presentation before this one, we need to resource legal aid clinics in law schools from the exchequer by, for instance, paying for the unit on clinical legal education. And this is not altruistic because it will ensure that you have more people who will be able to deal with legal aid and deal with the needs of the indigent. We also need to fund the establishment of clinics, the same way that CLE requires us to have moot court rooms. We need to have spaces for legal aid clinics. Another area is that we need to develop as a profession a career pathway for clinicians in the academy in law schools. Because you see, when you only have people who are, if you don't have a career trajectory for clinicians, then people sort of just stumble on that. So effective clinical legal education calls also for multidisciplinary training of law students, because the students may be required to engage non-law subjects like sociology, anthropology, science and technology. So in essence, we must look at the curricula of law schools so as to ensure that we are not patching legal aid on a framework that really will not enable legal aid to thrive. I thank you.
Thank you so much, Prof. That is truly, truly, truly thought-provoking. I did literature, and I was trying to, try to see where I will fit in your presentation. Then, in a very easy way, you introduced the word decolonization. And now, decolonization and someone who did literature is like, now what? to a lawyer, eh? Decolonizing law in law schools. Then you also brought in that aspect of disruption, okay? There's a day we were having a discussion in the field, and we were telling communities that legal aid is the aspect of having the mountain coming to Muhammad, because it's not all the time that Muhammad must go to the mountain. Okay, and talking about disruption, ladies and gentlemen, we truly need to ventilate all these discussions, all these presentations that were made. But it's 2 p.m. and there's a proposal that we go for lunch, then come back, and perhaps in about 10 minutes we have a reaction to all these presentations before we move to the presentation of the afternoon. And I'm aware that there's a way even in law you refer to afternoon. Morning is forenoon. How do you refer to afternoon? Is it post-noon? Whatever it is. So can we take that question? How many people are for that? Can we go for lunch? So will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it. Kindly let's go for lunch. Then we come back.